Apologies, I did have the wrong one loaded up. So again, the key agency responsible for enforcing the laws that prohibit employment discrimination. I talked about the Americans with Disabilities Act, Title VII of the Civil Rights Act, the Age Discrimination Employment Act, which prohibits discrimination against individuals 40 and older, as well as the Genetic Information Non-Discrimination Act. All of our federal laws prohibit discrimination on a variety of protected categories: race, color, sex, religion, national origin, age, disability, pregnancy, and LGBT. Retaliation is also prohibited under all of the laws enforced by the EEOC. Getting into our discussion today, the EEO laws prohibiting discrimination continue to apply, but they do not prevent employers from complying with any of the guidelines proposed by the CDC or some of their state and local health authorities. But employers need to also realize, of course, that there may be some issues that follow in the workplace, and they may need to consider some of those things. So again, in terms of pandemics, it is the U.S. Department of Health and Human Services, CDC, and the WHO who are going to give this information that provides some of this definitive information about pandemics. Pandemic planning and preparedness, everything from global to national and public health strategies to help the individual employers plan on how they're going to continue their operations. Now, getting back to the Americans with Disabilities Act, there is a three-pronged coverage of protection. No discrimination against individuals with a disability, having a record of a disability, or regarded as having a disability. With regards to a disability, we're talking about an individual that has an impairment which substantially impacts a major life activity: walking, sleeping, eating, breathing, and the like. When we're talking about disabilities, it can be both physical and mental, and sometimes we may see within group discrimination. For example, employers may be willing to hire or employ those individuals with the physical disability as opposed to the mental disability. When it comes to the ADA and pandemic preparedness, it does regulate the ADA, those medical inquiries that employers are allowed to make of employees and applicants. So there are limitations on disability-related inquiries as well as medical examinations. Employers are also prohibited from excluding individuals with disabilities from the workplace because they feel that they may have a direct threat that maybe they are able to accommodate and to reduce that threat. So we'll be talking about that in a little bit. And employers are also required to provide reasonable accommodation to individuals with disabilities unless they can establish an undue hardship, significant difficulty, or expense for the size of their particular operations. And this duty to provide an accommodation is ongoing even during a pandemic. When we're looking at these disability-related inquiries and medical examinations, we're looking at three stages of employment: before a conditional job offer is made, after the job offer is made, but before the individual begins working for the employer, and during employment. Other things you consider is also that any medical information that an employer obtains needs to be held in strict confidentiality. This may be medical information that's revealed during the hiring process, whether it's pre or post offer, and also protects the information that may be voluntarily revealed by an employee or applicant. Additionally, medical information needs to be segregated out of personnel files and put in its own confidential medical file with limited access. For example, maybe supervisors and managers who need to have information regarding an accommodation request, first aid personnel, and let's say investigations by government entities, EEOC doing an ADA investigation, insurance carriers, or workers' compensation. Now, one of the issues that employers may be concerned about is direct threat. And we're talking about direct threat. We're talking about significant risk of substantial harm to the individual or to others that cannot be eliminated or reduced by reasonable accommodation. If the individual with a disability poses a direct threat despite reasonable accommodation, then they're not going to be protected under the provisions of the Americans with Disabilities Act. But employers need to understand that this type of assessment needs to be based on objective, factual information, not on any type of subjective perceptions or any irrational feels about a specific disability or disabilities. Now, as we talk about this direct threat analysis, we need to look at the duration of the risk, the nature and severity of any type of harm, the likelihood that will occur, and the imminence of the potential harm. Or as one of the things I used to remember, can the employer establish a specific imminent harm? All right, as we go through that direct threat assessment. Now, speaking about the pandemic, and there's a lot of gobbledygook there language, but we get to the very end that when we're looking at the pandemic and the seriousness of what happens with the pandemic, then for our purposes of discussion, the COVID-19 pandemic does meet the direct threat standard. All right, so we do need to be concerned about that in the workplace. Now, before the pandemic, you can look at guidance that we have by the EEOC. Health and Human Services also can advise the employer about how they can plan for pandemic preparedness. Maybe, for example, identifying a pandemic coordinator or some type of team that have roles and responsibilities in dealing with their preparedness and response planning. So now I'm going to get into some of those questions that we're hearing from the employer, and I'm trying to do as much as possible to give you a direct yes and no answer. So these are just a few of the questions that we're hearing from employers. May an ADA-covered employer send employees home if they display influenza-like symptoms during a pandemic? Yes. All right, so when we're applying the principle about the current CDC guidance and COVID-19, this means that an employer can send home an employee with COVID-19 or symptoms associated with it. So the CDC does state that employees who become ill with symptoms of influenza-like illness at workplace during the pandemic should leave the workplace. All right, so that answer then is going to be yes. The next question that I have here is, during a pandemic, how much information may an ADA-covered employer request from employees who report feeling ill at work or who call in sick? So with regards to this type of line of inquiry, the employer should be asking those questions that are related to those symptoms of a pandemic virus. The flu, fever, for example, chills, coughing, and sore throat. This does not mean, of course, that you can have everything in the kitchen sink. This is not an opportunity for the employer to ask about other things not related to the pandemic. So, for example, talking about a person's mental health history and asking questions about that. Next question. During a pandemic, may an ADA-covered employer take its employees' temperature to determine whether they have a fever? The answer to that also is yes. Because the CDC and the state and health authorities have acknowledged that community spread of COVID-19 and issued precautions as of March 2020, employers may measure employees' body temperature. Again, as with all medical information, the fact that an employee had a fever or other symptoms would be subject to ADA confidentiality requirements. Let's go to our next set of questions here. When an employee returns from travel during a pandemic, must an employer wait until the employee develops influenza symptoms to ask questions about their exposure to pandemic influenza during the trip? The answer to that would be no. All right. Asking whether or not that you've been exposed to it during a trip is not really a disability related inquiry. And the CDC and state or local officials may recommend that people who visit specified locations remain at home for several days until it's clear that they do not have the pandemic symptoms. So an employer may be asking that employees, are you returning from these locations where there was some evidence of the pandemic influenza? Going on to the next question, during a pandemic, may an employer ask employees who do not have influenza symptoms to disclose whether they have a medical condition that the CDC says could make them especially vulnerable to influenza complications? The answer to that is going to be no. If pandemic influenza is like seasonal influenza in the spring or the summer, that would making disability unrelated inquiries or requiring medical examinations without symptoms a prohibition under the Americans with Disabilities Act. All right. But maybe the employee might voluntarily disclose that they have a specific medical condition or disability. They may put them in that increased risk of influenza complications. If the employer gets that information, once again, they need to be sure to keep that information confidential. Let's go on to our next set of questions here. And I realize I'm going rather quickly, just trying to give you the flavor of this. May an employer encourage employees to telework as an infection control strategy during a pandemic? The answer to that is yes. Telework is an effective infection control strategy, and it's also familiar to ADA covered employers as a reasonable accommodations. Next question. During a pandemic, may an employer require its employees to adopt infection control practices? Let's say regular hand washing at the workplace. Answer to that is yes. As we are aware, regular hand washing, coughing and sneezing etiquette, like coughing into your elbow, proper disposal of using a tissue. These things don't necessarily implicate the ADA, and these are recognized as ways, once again, to keep the pandemic at bay. Next question. During a pandemic, may an employer require its employees to wear personal protective equipment designed to reduce the transmission of pandemic infection? The answer of that is yes. So the employer can ask the employees or require them to wear, let's say, things such as masks or gowns. They may have to provide accommodations. So let's say you're having a requirement that employees wear gloves. There may be individuals with disabilities that may have allergic reactions, and you may need to have to give them, let's say, non-latex gowns, or maybe gowns designed for individuals who are using wheelchairs. So you still have those accommodations considerations. Let's go to our next set of questions here. May an employer postpone the start date or withdraw a job offer because the person is 65 years or older, which puts them in this higher risk category from the COVID-19? The answer to that is going to be no. The Age Discrimination Employment Act prohibits discrimination against individuals 40 or older. And so we would find that to be discriminatory.
Maria, this is Josh. We actually had a question submitted specifically to that, a little more in depth. So as companies move to bring back employees to the workforce, how do they avoid age discrimination if they don't bring back employers who are over 60? It appears that the state plan does not encourage, or I guess the question says the state plan appears to not bring back employers who are 60 plus until phase 3. So how would that be addressed?
Whoa, you're asking me hard questions. If there's one thing I am, it's honest. So when I say I don't know something, I'm going to tell you I don't know. I don't have a direct answer on that. My initial gut feeling is the following, as someone who's been with the commission over 28 years. Case by case analysis is usually the best way for an employer to go, and also for an employer to establish a business necessity. The employer can do case by case analysis and establish business necessity. They're on safe footing. What would trouble me about that is that my opinion, this is my personal professional opinion, you can't lump all 60-year-olds into the same category and say they all have the same type of health status. So, you know, I almost want to say this may be the situations where you may have federal law butting heads with state law, and oftentimes federal law may supersede state law. I don't know if that would be the case here, but it's certainly, for me, from the commission, raises a lot of concerns and warning lights that I would tread lightly on that. Now, okay, people have real specific questions about that, they can contact me later on, because we have a group of 4 attorneys at headquarters to handle complex questions.
Okay, Maria, thank you for the clarification. And I'll for folks listening, we'll dive a little deeper in that issue, and perhaps at the end, Eric, our attorney from Hush Blackwell, may be able to provide some insight on that. If not, we can follow up later. So quick reminder for folks, if people have questions, they can submit them through the webinar. We will try to get to as many as we can. If we can't get to them during the presentation, we hope to answer them afterwards as a follow-up. So Maria, if we have about 3 minutes left for you, if you could, and we can certainly provide answers that she has or additional information as part of the presentation later. But Maria, do you have any kind of closing thoughts as we?
Yeah, let me go ahead and move on and state that employers need to constantly go back to the websites of the various governmental agencies that are providing the most up-to-date information about COVID. So go to the EOC website, go to the Centers for Disease Control, Department of Labor for OSHA wage and hour. They all have landing pages regarding COVID in the workplace. For EEOC, we are updating the guidance that we have. So we have a short question and answer, what you should know about COVID, the ADA and the Rehab Act, and we continue to update. We also are updating our previous pandemic preparedness guidance that was prepared during the H1N1 outbreak, but updating that for COVID with the new information in bold. And we keep going back and updating that, which is why you have to go back. And we also have a pre-recorded webinar with questions and answers about COVID. You can also find a transcript about that. I would say ask questions. That's the best way to do. Go to those websites, gather the information, ask questions. I'm the contact person in Wisconsin for employer representatives interested in training, outreach, and for technical assistance, meaning to ask EEO questions. So I'll speak with an individual, and often I'll send them an email with some links to our guidance and copy and paste certain sections. Keep it in mind that no one at the commission provides legal guidance, but we will explain our laws and share some best practices with you. And I have on the screen my direct phone number that is direct, as well as my email address. Was there anything else before I close down this PowerPoint?
That's great, Maria. Thank you very much for the presentation. And for folks listening, her contact information is up there, and we will share that as part of the webinar after. So, Maria, thank you very much for the presentation. Great. And you can turn your camera and screen sharing off, Maria, and I will now introduce our next panelist, Corey Walton. Corey, are you there, Corey? Can you hear us?
I am here.
Okay. Great, Corey. Corey has been with the U.S. Department of Labor Wage Hour Division since 1997. He spent 15 years as an investigator, investigating hundreds of cases under several laws, including the Fair Labor Standards Act, Davis-Bacon, and the Family Medical Leave Act. Over the past 8 years, Corey has served as the Community Outreach and Resource Planning Specialist in Wage and Hours Minneapolis District Office. In that capacity, Corey spends most of his time organizing and conducting DOL educational and training events throughout Wisconsin and Minnesota. So Corey, thanks a lot for taking the time today. Looks like you're up and running, so take it away.
Thank you. Thank you so much, Josh. Good morning, everyone. Once again, I'm with the Department of Labor Wage and Hour Division, and I'm going to talk about our slice of this COVID-19 era we live in, which is the Families First Coronavirus Response Act. So since April 1st, when the law first went into effect, we've been up to our eyeballs in inquiries, compliance assistance, complaint taking, etc. So I'm going to zero in on that because that's what our agency is dove into in the last 30 days or so. So the Families First Coronavirus Response Act is an act that's basically made up of two components. There's the Emergency Paid Sick Leave Act and the Emergency Family Medical Leave Expansion Act. I'm going to talk about both of those. Just as a reminder, this law came into effect on April 1st, but it does have an expiration date. So it has a shelf life through New Year's Eve. So unlike many laws, this has an end. I'm going to hit on the 5 topics that we get all of our questions in. I'm going to talk about coverage, so which employers are subject to the law, employee eligibility, which employees can take the leave. I'm going to talk about reasons for the leave, so under what conditions and for what specific reasons employees can take time off. I'm going to talk about how much leave they can take off, and then I'm going to talk about how much they are required to be paid when they're off on the leave. So first, let's talk about coverage. There's 2 sectors, private and public sectors, and both of them have their requirements. For the private sector, for the FFCRA to apply, the employer has to have fewer than 500 employees. So if you have 499 employees in the private sector or less, then you're covered by this law, and that includes not-for-profits. In the public sector, for public agencies, regardless of the number of employees they employ, they're going to be covered by the FFCRA. So if they have 1 employee or 10,000 employees, doesn't matter. They're going to be covered. So that's the coverage part of it. the qualifying reasons for the leave. So under what conditions and for what reasons can the employees take the leave? And the first three reasons are on the screen. I want to pause here and let everyone know and just kind of highlight this, that there are a lot of employees requesting time off for COVID-19 related reasons. But as far as the FFCRA goes, there are only 6 specific reasons employees can request time off under this law, 6 and 6 only. So everything that's COVID-19 related that employees need time off for don't necessarily fall under this umbrella. So I'm going to talk about the reasons that do. So reasons 1 through 3, the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. Second reason, the employee has been advised by a healthcare provider to self-quarantine related to COVID-19. And third, the employee is experiencing COVID-19 symptoms and is seeking a medical diagnosis. Just notice on reason number 3, that's a 2-pronged test. The employee is experiencing the symptoms and at the same time is actively, you can insert that word actively, seeking medical diagnosis. Those are the first 3 reasons. As you can see, the first 3 reasons have everything to do with the employee who is asking for the leave and their condition, as opposed to reasons 4 through 6. Reason number 4 is caring for an individual who is subject to a federal, state, or local quarantine or isolation order related to COVID-19 or has been advised by a healthcare provider to self-quarantine. Reason number 5, which a lot of employees are taking time off for already. The employee is caring for his or her child whose school or place of care is closed due to COVID-19 related reasons. And reason number 6, no one should be taking time off under reason number 6 yet, because the U.S. Department of Health and Human Services has yet to identify a substantially similar condition to COVID-19 for an employee to take time off. So reason number 6 right now, it doesn't mean a condition won't be identified between now and New Year's Eve when the law expires. But for now, the Department of Health and Human Services have not identified a condition. So here's the general rule, you guys, and then I'm going to talk about the exception. The general rule is eligible employees, all eligible employees who work for covered employers must be allowed to take time off under the FFCRA. There are 2 exceptions to that rule. There's the small business exemption, and then there's the exemption that applies to healthcare providers / emergency responders. So I'm going to go through both of those exceptions right now. The first is a small business exemption. So, and it's basically a 3-pronged test. That's the way you can look at it. The first prong is the business has to have fewer than 50 employees for this small business exemption to apply. So if you have 50 employees or more, then you can't claim this exemption. Second prong, the employer is denying leave for an employee who is requesting leave for only one of those 6 reasons. So for the other 5 reasons, the small business exemption does not apply. But if the employee is asking or requesting leave to care for his or her child whose school or place of care is closed, then the small business exemption can be the response. And the third prong is the requirements of the FFCRA jeopardize the business viability. So how does this work? So an employee approaches an employer with fewer than 50 employees and says, I need time off for this one reason and one reason only. The employer can say, I'm sorry, I can't give you the time off because your absence would jeopardize the business viability of the company. So that's the way, walking through the process, that's the way it works. So the only question really is, what does jeopardize the business viability mean? So I'm not going to go through these individually in the interest of time, and all this language is in the regulations, but one of these 3 bullets have to be shown by the employer. And the small business exemption, just like the healthcare provider / emergency responder exemption, is nothing the employer has to apply for or register or send anything to the DOL. What he or she does is when the employee approaches them for the request for leave and they deny the leave, the employer is required to document why that individual, and this is an individual employee by employee analysis, they document why that particular employee meets one of these 3 categories, and that's the reason why they're being denied the leave. So again, it's an exception to the general rule that all employees are entitled to the leave, and you have to document why and keep that documentation documentation on file. Second exception to the general rule is employees who fall into the category of a healthcare provider or an emergency responder. The employer can deny those employees leave as well. And this denial of the leave can be in response to any of those 5 reasons under FFCRA. So while the small business exemption can only be in response to leave requested to take care of their child, their school is closed, or the healthcare provider unavailable, the healthcare provider and emergency responder exemption can be in response to any of those 6 reasons why an employee would take leave under FFCRA. So the only question becomes, and this is this language is in the Act, in the regulations, is who is a healthcare provider and who is an emergency responder. Under the law, this healthcare provider term is used very broadly, more broadly than you're probably used to, especially under the traditional FMLA. So as you can see, the first 3 words under healthcare provider is anyone employed at is a healthcare provider. So a CNA at a nursing home is a healthcare provider. A PCA that works for a home healthcare agency is a healthcare provider for purposes of this exemption. So again, all of this language is in the regulations, but if you think or you suspect that one of your employees or you as an employee fall into one of these categories, just be aware of this exemption. There are the list of emergency responder job titles that are typically falling into this category. Again, all this language is in the regulations. Again, just to recap, the rule is all eligible employees who work for covered employers are entitled to request and get the leave. 2 exceptions, small business exemption exception and the healthcare provider / emergency responder exemption. With most laws, almost all laws, there's some type of poster requirement. I want to talk about that real quickly. And FFCRA is no different. So there is a poster requirement. So employers are required to post posters of this law, but there's 2 differences I want to highlight. The first difference is, since we live in an era where a lot of employees are working away from the establishment, teleworking or whatever, then the employer can fulfill or meet this requirement by sending by email, posting on their website, regular mail, the poster out to the employees. So whatever means it takes, if you don't have employees coming to work like they traditionally would, then that poster should be going out to the employees in a way. And for example, if it's posted on their website, just make them aware it's there. That's the one difference. The second difference is the language requirement. For most of our laws, if you have a substantial number of your employee sector who speak another language other than English as their primary language, then there's usually a requirement that the poster be posted in that language as well. For example, Spanish-speaking employees. Under the FFCRA, the only required version for the poster is the English version. So that's a little different than most poster requirements. I want to talk briefly about the employee layoffs or furloughs or job closings and how that affects the employee's FFCRA leave rights. And this is very simple. I'll read the bullets and then I'll tell you the rule. FFCRA requirements are not applicable prior to April 1st. If a business closes after April 1st, but before an employee takes leave, FFCRA requirements do not apply except to those days from the April 1st to the date the employees were laid off. And if a business is open but lays off its workforce, move this, I can't see behind this. Whoops, sorry about that, you guys. But if the business opens but lays off parts of the workforce, et cetera, furloughed, et cetera. Let me just crunch all of these bullets up into one major point. A furlough, a layoff, or a job closing, establishment closing, affects the employee's FFCRA rights by way of cutting them off. So in other words, when one of those big events happens, what happens is it shifts the reason why the employee is taking leave from whatever 1 through 6 reason it was to the job closing or the furlough or the layoff. So this is these 3 events are very important events when it comes to the FFCRA rights of the employees. It essentially cuts them off. Even if someone is on leave and the business closes, now the reason why they're not working is because the employer has no work for them because the business is closing, not reasons 1 through 6. So these are important events that happen that cut off the rights for the employees to take the leave. So I'm going to circle back to the first bullet for 1 second. April 1st, anything happening before April 1st. So if an employee was on any kind of leave, even COVID-19 related leave, prior to April 1st, FFCRA provisions do not apply to. Only leave taken April 1st or later. Up until now, I've been talking about the FFCRA as a whole. Right now, real quick, I want to talk about the separate components. There's the emergency paid sick leave component, and there's the expanded FMLA component. The emergency paid, and these are separate acts under this FFCRA paid sick leave umbrella. The two characteristics I want to talk about EPSLA leave is number one, it can be taken for any of the 1 through 6 reasons, this chunk of it. And number two, it's only for a limited amount of leave. So it's 2 weeks of leave, paid leave, based on the employee's regular work schedule. There's a cap of 80 hours. So if they regularly work 35 hours a week times 2, they get 70 hours of this EPSLA leave. If they regularly work 40 hours, it's 80 hours. If they regularly work more than 40 hours, it's still an 80-hour cap. If their schedules fluctuate, I'll show a document at the end of this presentation that you can go to where there's a formula for computing based on a sample 6-month time period of what you use to determine how much leave they're entitled to under the EPSLA. The eligibility for this type of leave is simple. All employees who work for covered employers are eligible. No minimum amount of days, no minimum number of hours had to have been worked, etc. If you're working for the employee, you can take the leave. This is pretty straightforward. How much are employees entitled to be paid during the leave? The employer should zero in on 3 rates. The employee's regular rate of pay, whatever is an hourly rate, or if any bonuses or commissions have to be included, that's one. The federal minimum wage, which is $7.25, or any applicable state or municipal minimum wage. So that would mean the higher of any of those is what we're looking at as far as how much you pay the employee per hour of leave taken. With one caveat, for reasons 1 through 3, let's say, for example, $15 was the employee's regular rate of pay. For reasons 1 through 3, and they're taking leave for any of the first 3 reasons, they get 100% of that $15. In other words, $15 an hour per leave taking with a cap of $5.11 a day and $51.10 in a 2-week time period. If they are taking leave for reasons 4 through 6, they only get 2/3 of that regular rate. Or in my example, $10. Why? Because reasons 4 through 6 are 2/3 reasons. So reasons 1 through 3, the full regular rate. Reasons 4 through 6, 2/3 of that. And there's a cap of $2 or $200 a day and $2,000 for that 2-week time period. The expanded FMLA is different. Set aside the EPSLA. That's 2 weeks tops, 80 hours max. The Emergency Family Medical Leave Act is a separate component. Its characteristics, number one, it's leave taken for only one reason only. And you see the reason there. It's reason number 4. Care for his or her child or daughter, a son or daughter whose school is closed or a place of care is unavailable. Second major characteristic, up to 12 work weeks of job protected leave. EPSLA, 2 weeks. Emergency Family Medical Leave Act, up to 12 weeks. Bullet number 3, the first 2 weeks are unpaid, but the employee can, not the employer cannot require, but the employee can elect to use the 2 weeks of EPSLA leave and plug it in those 2 weeks and turn that, what would otherwise be an unpaid period, into a paid period. Second option for the employee for that 2-week unpaid period is to use the employer's provided leave, assuming they have accrued leave available. Again, these are employee options only. The employer cannot require. But whatever happens that first 2 weeks, the remaining 10 weeks are paid at 2/3 the employee's regular rate. Again, reason number 4 is a 2/3 reason. The eligibility requirement for the expanded FMLA is 30 days. EPSLA, no such requirement. Expanded FMLA, 30 days. So they had to have been employed with the employer 30 days prior to the initiation of the leave. Again, not to beat a dead horse, but only one reason and one reason only on the expanded FMLA. And there's the information I already gave you about the employee's options to shift the paid leave or the accrued leave over and use that during the unpaid period. One more big point I want to make about the expanded FMLA, and that is this. The FMLA and the expanded FMLA work together in determining how much leave an employee can take. So for example, for the employee, let's say a new mom gave birth in January and used 12 weeks for the birth and the bonding period. When April 1st rolled around and the expanded FMLA leave came into existence, she had 0 hours to use for expanded FMLA because she used it under the old FMLA. So that's for purpose. Now, EPSLA is a separate thing. She still has those 2 weeks, but under FMLA and expanded FMLA combined, employees get only 12 weeks. Here's the FFCRA resource page. The third bullet down is the Family First Coronavirus Response Act Q&A. On that document, there are questions 80 through 86. Walk through any situation where you might have an employer with a employee with a fluctuating work week and determining what number of hours you use for the EPSLA leave or the expanded FMLA, or if an employee has fluctuating pay, for example, a piece worker. There's a formula will walk you through how you make that computation based on a sample pay period. The last bullet is my email address. If you want to jot that down, if you have any questions, or I can send, or Josh, you can send this PowerPoint to wherever you'd like. And that way you can just click right on the links to get to where you want to go. So in a nutshell, that's my presentation, everyone. I know I went through everything rather rapidly, but hopefully people got some questions answered.
No, Corey, thank you very much. That was great. And like Corey mentioned, we are going to have this available to folks afterwards. I'd like to thank Corey for the presentation. If folks have any other questions, please email me or Corey directly. I'm going to now introduce Eric, who's our next panelist. And Corey, you can go ahead and sign off, and Eric can share. Eric is a partner with the Milwaukee office of the law firm of Hush Blackwell. He's the chair of the firm's national labor and employment practice. Eric provides advice, counsel, and litigation assistance to his clients on a wide range of labor and employment issues, including the COVID-19 pandemic and the recent federal legislation that was passed in response. I will let Eric answer any questions about the Korean flag that's flying behind him, for those of you baseball fans. But Eric, thanks a lot for the time, and why don't you take it away?
Thanks, Josh. Appreciate the opportunity, and certainly appreciate everyone who's on the line with us today. I also wanted to just echo my thanks for Maria and Corey. I think it's a unique opportunity for all of us on the line to sort of hear directly from the horse's mouth the agencies that have the challenging task to sort of interpret and implement these laws in the context of this different world that we're living in. All of us are kind of going through this together for the first time. As Josh mentioned, I am a labor and employment lawyer. So what I've been doing over the last 6 or 8 weeks is helping my clients understand rights and responsibilities in the context of the pandemic and the laws that are being passed. And what I'm going to hope to talk about today a bit is to sort of distill and take some of these key legal principles that Maria and Corey have shared and talk about how my clients, at least, are navigating and implementing those. So I have sort of a list of items that I'm going to go through. But to start, I thought I would cover that excellent question that came up during Maria's section of the presentation and just offer my input on it. And I'll do that off the top just so I don't run out of time or forget. I'm sharing my screen with you right now. What you should see is the copy of this Badger Bounce Back Plan that the governor's office and the state health department have published. And I wanted to just go to this so we sort of saw, I think, the source information when that question came up about what we do at the point at which we're ready to return to work for individuals who may be over 60 years old. So to the extent that you haven't read this already, I would encourage you to check it out. It's on the state DHS webpage. But it's got the basic background information about what the various benchmarks the state and the health department will be looking for, guidelines, employer guidelines, and then these various different phases, safer at home, and then phase 1, 2, and 3 that we hope to be able to get to based on the various metrics that we achieve. At the bottom of the plan, and it's this asterisk that you can see here. You know, this is even when they're opening schools and daycares and restaurants and bars, the asterisk says people over 60, including employees and those who are medically vulnerable, should continue to shelter in place. So this, I think, is the basis for that question, which is, okay, if I'm an employer and I'm looking to return employees back, do I have the right, or should I be excluding individuals who are in one of those two categories, medically vulnerable or over 60? And I think Maria's instinct is exactly what I would expect, and what I would advise my clients is that it would be a very risky proposition for you as an employer to be making that decision for your employees based on this sort of health guidance. Instead, and I think it's interesting the way that this is written, is that ultimately the direction is from the state agency for those who fall in those categories to request or exercise their rights to remain out of the workplace, or at least out of a situation where they might be exposed. So I think the way that an employer will experience this is not that as we return to work, we should be excluding people who we believe are medically vulnerable or over 60, but instead to make sure that we're having that interactive dialogue, that case-by-case situation that Maria described, with folks who might be in this category to determine whether they are comfortable in returning. Because ultimately, you as the employer probably have the obligation, if you've got somebody who's over 60 or in a medically vulnerable position who comes to you and says, I understand that I would be typically part of this return to work process, but given my age or given my medical status, I don't feel comfortable doing so at this time. What are my alternatives? That then triggers your obligation as the employer to sort of engage in that conversation to see whether this is a person that maybe we could keep in a remote work setting, or whether there are other accommodations that we could grant. So the takeaway, I think, is that you should not explicitly exclude these people as you are making those plans, but to be prepared to honor requests that they may raise based on these legitimate concerns. So an excellent question. And I suppose I should also, give the same caveat as others have. We're all in uncharted territory here. So there isn't case law on that issue, but I think that's going to be my advice for my clients to help avoid liability. I'm going to move here, and the resource that I'll use is sort of just a guide to walk through with you, is an article that my colleague and I put together, which is on the Hush Blackwell website. We have, our law firm has a resource page on returning to work, COVID-19 returning to work. We've prepared various different thought pieces on that, and on that page you'll find a link to this article, which sort of outlines a bunch of these different employment-related considerations that we think employers should have front of mind as they're thinking about what the return to work looks like. Many of these have been topics that Maria and Corey have already touched on, but I'll just sort of highlight these in the order that I've got them listed here. Obviously, one framework is that you're going to need to be mindful of, what your particular jurisdiction has in place in terms of a stay-at-home order. Employers in Wisconsin, of course, are currently still subject to the extension of the safer at home order that the governor and the state health secretary provided. You may know that there was oral argument yesterday at the Wisconsin Supreme Court in a case that was brought by the Republicans in the legislature, challenging the governor's authority to extend that. We are anticipating that the Supreme Court will rule relatively soon on that, either at the end of this week or perhaps early next week. And then, it's anybody's guess what the outcome of that may be. If the court grants the relief requested by the petitioners in that case, the Republicans in the legislature, it may be to simply throw out that order, which leaves us in sort of an interesting space. The result may be then that the governor is required to negotiate and go through a rulemaking process, which will be sort of an interactive process with some of the other legislators. But there are a bunch of question marks there. All that to say is we're in the status quo and where we are, obviously in Wisconsin, we still have the stay-at-home orders in place. So, I would encourage you to familiarize yourself both with the original order and the revised order, because, even in that revised order, there are components there that are allowing certain non-essential businesses to begin to open in limited ways. So be familiar what those rules say. At the point at which you get the green light to start going back to work in some capacity, it's important to think about what various new work policies and rules you may have in place. Maria talked a bit about this concept of exclusions from the workplace. The guidance from the EEOC and CDC is quite clear that you do have the ability to exclude employees who are reporting symptoms of COVID or have tested positive. I'll touch on it again maybe in a few minutes, but a follow-up question on that, of course, is sort of the extent to which an employer can require testing. Again, these agencies have given fairly wide latitude to allow an employer to conduct testing as a condition of returning to employment. I think a key caveat there is what Maria mentioned, which is that to the extent an employer is doing inquiries, testing, anything like that, that needs to be in the same context and understanding that it needs to be focused on COVID, that it's not medical inquiries or testing that's going to expand into non-pandemic related issues. That's where you're going to be running afoul of various laws like the ADA. In addition to sort of those testing and return to work issues, you're going to want to be thinking about what your hygiene and sanitation policies and what your administrative and engineering controls are. When we talk about hygiene and sanitation, you'll want to make sure that you have plans in place that talk about sort of the extra cleaning that you're going to be doing, disinfecting, the type of cleaning and steps that you'll be taking to ensure that when we bring employees back, they have a clean workplace. And then in addition to the actual just cleaning, what are the sort of additional steps that we're going to take to try to ensure that employees have a safe workforce, or a safe workplace? It's going to depend on the nature of your business, how aggressive those steps need to be. As an example, we've seen outbreaks here in Wisconsin in certain industries where employees are required to work in very close contact, like meat processing facilities. If you've got employees in close contact, the employer is going to need to be more aggressive in terms of the steps that it can take in terms of installing plexiglass barriers, changing the workflow to allow the work to continue in a way that employees aren't exposing each other. In certain office workplaces, there may be less aggressive steps that are necessary. It may be, simply adjusting work schedules or providing protective equipment. OSHA has useful guidance on sort of the various different ways and steps that an employer can take to ensure that it's keeping employees safe. I mentioned the work schedules, travel restrictions, limiting public access. These are all steps that my law firm is taking, for instance, as we are thinking about returning to the office. These are steps that are going to help in that more gradual transition to be conservative as we think about ways that we can protect employees. Personal protective equipment. Maria touched on this. I think this is a question that we have had coming up a lot from clients, particularly this concept of face shields or masks or face coverings. As a general rule, you've now got guidance from OSHA and the CDC recommending face coverings for all individuals when they're out in public or around other individuals, which means in most instances where they're going to be exposed to coworkers. This is a change from what we saw maybe a couple weeks ago where the CDC wasn't quite recommending that. That is now an evolution of their position. So the recommendation and what I would expect to see as we return to work in virtually all workplaces when employees are going to be exposed to others. Many or most employers are going to be providing face coverings for employees. A couple interesting questions here. Can the employer require a face covering? The short answer is yes. As long as the employer is aware that there are some limited instances where they might have to grant an accommodation. Maria referenced that. If somebody has a medical reason, like perhaps they have asthma or a breathing condition that prevents them from being able to do their job while they're wearing a face covering, that could be a reason why we might have to exempt somebody. Or if somebody has a religious reason why they're not able to have a face covering, we might have an exemption in that instance. But again, those are limited. We should handle those on a case-by-case basis. But a general rule that an employer provides in that context probably is lawful and enforceable. If the employer can require that, a follow-up question is whose responsibility is it to provide or pay for those face coverings? If the employer has that rule, is the employer required to be the one who provides them? Well, some states have passed specific laws that address this. In New York and in Michigan, for instance, we've seen the legislation that specifically identifies the duty there belongs to the employer. So the employer has to be the one providing and paying for the face coverings. we don't have a rule like that in Wisconsin yet. My expectation is that we might see a rule that would require that from an employer's perspective. And the advice that I'm giving my employer clients is that if you're going to require it, my recommendation is that they make them available at the employer's cost. You may have a rule where you say employees could choose to use their own, and that's going to be acceptable in most instances. I think my caveat there is that some of the, what I would describe as more novelty face coverings and scarves may not meet the CDC requirements of a multiple layer cloth that would actually, serve the purpose that we're looking for. So if an employer is going to allow employees to bring in their own, be thoughtful about making sure that those employee provided ones are meeting the applicable standards. Moving on here, some employee and human resources issues, and we've touched on this a bit before. What about recalling fewer than all employees to work? So, many businesses who may have been deemed non-essential and affected by the stay-at-home, when we're able to return to work, I would say most businesses are probably not going to just snap back and return back to 100% capacity. You're going to be coming back in phases. As you think about the manner in which you're going to be slowly scaling back, it is important to keep in mind some of the employment discrimination considerations that you might have there. You have wide latitude as a business to make decisions about who you bring back and when you bring them back based on legitimate business considerations. But those need to be non-discriminatory, objective criteria, like whether the employee is essential to critical operations, whether they have essential skills, the kind of work. We need to make sure that those return to work decisions aren't having an adverse impact on people in a particular race, national origin, age, sex, pregnancy status, right? If we're returning folks to work, but we're leaving out people in a protective class, that creates some potential liability from an employer. Employing high-risk employees or these requests for an accommodation. This is what I was touching on before. The way I think, again, this is going to manifest itself is that rather than the employer saying, well, we're excluding a class of employees, the employer may make its decision based on job classification or group. And then I anticipate that you may have employees who will come and say, I have a medical condition, or because I'm in an elevated age category, I don't feel comfortable coming back to work. That's where I believe the employer will have an obligation under the ADA or the ADEA to engage in a reasonable accommodation analysis. So for folks who may be over 60 or have those medical conditions, there might be a requirement for the employer to think about whether we could continue to allow those folks to work remotely, or whether there are other accommodations that we might be required to consider as we think about returning them to work. Teleworking, of course, that's what many of us are doing right now. Teleworking or working remotely is something that's being recommended for all businesses, even essential businesses. And here's where I think is an interesting sort of spin on what we just talked about. Many businesses right now are accommodating and doing teleworking in large part for employees who can do that. I anticipate to see certain employers, as they rotate back to work, starting to ask employees to return or require employees to turn and perform some of those office functions in the office. You might have some employees who say, I actually don't feel safe coming in yet, or I would prefer to continue to telework. I think this is going to create some interesting back and forth because an employer is in many instances not required to grant an accommodation for someone to work remotely if there are essential business reasons why the employer needs them in the office. We're going through a scenario here where we've been having a lot of people work remotely. So when we have some of those conversations now about somebody who says, well, actually, I have a legitimate reason why I want to continue to work from home, can the employer make the case that it is essential that that person come into the office? I think it may be more of a challenge for the employer to do that now than it would have been prior to the pandemic. So something to think about. The last thing I'm going to touch on here is this concept of protected concerted activity. So something that you're seeing bubbling up in various different workspaces is this concept of whether employees are comfortable returning to the workplace, if they think that their employer is doing what it should be to provide a safe workspace. What I am anticipating we will see as more businesses continue to reopen is the possibility that some employees may be objecting or arguing that their workplace is not yet safe and that should not be required to return. One federal law that we think could be implicated in this context is the National Labor Relations Act. As you may know, that's a law that doesn't just apply to unionized employers, but virtually all employers. And it protects employees' rights to engage in concerted activity for the purpose of mutual aid and protection. In this context, we think that employees who raise health and safety concerns in the workplace that are related to COVID-19 exposure or PPE issues arguably could be protected under this. So if an employer terminates somebody because they complain, that creates real risk of interference with these rights, a claim under the National Labor Relations Act. One example we're reading about in the news, of course, is the issues going on with businesses like Amazon, where individuals or workers who have raised those concerns may have been terminated. The businesses will articulate legitimate business reasons for why they made that decision, but it creates this legal risk. And frankly, even above and beyond the legal risk, creates some pretty significant PR risk. You know, you don't want to be the employer who's showing up on the front page of the local paper because you've got employees who say, my workplace wasn't safe, and when I complained, I was terminated. So my takeaway there is that to the extent employees raise these concerns, you as the employer should take them seriously, should address them, and make sure that we're not retaliating against employees who raise them. I think that's all the items that I have on my list. There are a number of other issues that I know you as employers are dealing with, and we could do a whole session on things like work headcount, eligibility for the Paycheck Protection Act, the expansion of Wisconsin's workers' compensation laws, you know, how to continue to manage RIFs, layoffs, and furloughs. Maybe that will be a topic for another day that Josh can organize. But that's all I have, and I appreciate the opportunity to speak with you.
No, Eric, thanks a lot. That was a great presentation. I guess my final question for you is, why don't you, we have a minute, why don't you tell folks why the flag is behind you?
Sure. So we've got the South Korea flag up behind me today. I collect and fly different flags. I like to have them flying as they connect to any particular thing that's going on in the world. I felt like South Korea deserved a shout out for a lot of reasons, right? South Korea is kind of having its heyday. Oscar award-winning Parasite, amazing movie, which you should see if you haven't seen it yet. A country that, you know, say what you will about the way that the state and federal government in the US has handled the response. I think we could take a few lessons from South Korea in terms of their aggressive response and the way that they've handled the COVID-19. And then, as Josh mentioned off top, we've got baseball coming back. The Korean Baseball League is back. They're on ESPN. I think it's a terrific opportunity for us to start to get sports back in our life. So that's the reason that I'm celebrating South Korea today.
No, that's great. No, Eric, thanks a lot. We had one other question for Corey that I'd like to share, and then in addition to that, I'm going to give, just post that question, I'm going to give a quick wrap up about the Talent Development Council. Corey, did you get that question that I messaged you, or should I read it for you?
Yeah, go ahead and read it.
Okay. The question is the expanded FMLA only applicable for the care of dependents, or can the expanded FMLA be used by a person who has COVID-19 related symptoms?
Right. It's only for one reason, and that is to take care of a child whose school is closed or their child care provider is unavailable. So that's the only reason the expanded FMLA can be used. So those other 5 reasons, including their own symptoms or their own condition, can only be taken under EPSLA, not expanded FMLA. Okay,
great, Corey, that's great. Well, thank you, all of you who have joined. I just want to give a little plug here for the Talent Development Council of the Wisconsin Workforce Development Association. Kind of 3 reasons that we're, wanted to mention as reasons to join the Talent Development Council. First is access to programming like we've seen here today. As part of the Workforce Development Association, TDC members have access to in-person policy briefings, legislative updates, and industry insight from the policymakers and workforce leaders that we have today. Another reason is connection to decision makers. Communication between members of industry associations in the state and the workforce systems clearly lead to better understanding of the barriers and opportunities to workforce. And lastly, one of the more important reasons is influencing your ability to influence funding priorities. The Talent Development Council is the premier platform in Wisconsin to align your workforce needs as an employer or as an industry trade group with the funding priorities of the agencies that address them. So I want to put a plug in for membership of the Talent Development Council. Please contact me if you have any questions about what that looks like. I want to thank everybody for participating today, especially our panelists, Maria, Eric, and Corey. I will post information about the webinar, including for those who want to review it, who may not have been able to participate. Eric mentioned the blog post that he had on the Hush Blackwell site. We also have a copy of that on the WWDA site. So that's wwda.org on the blog section. So his post is there, and we'll also have information about today's webinar. So again, I want to thank everyone for participating and wish you all a great week. And thanks for coming today, everyone.
Thank you, Josh.
Thank you, Josh.
Thank you very much.